right, this isn't the, is
This
this,
is the same case that we had on Friday.
all right,
I recapitulate a little bit what happened. So
Sure.
he got probation on clause number 2025 CR 002719. After he had pled, but before he was sentenced, they filed an indictment which was coming out of the same fact pattern, theft case, which is 2025 CR 007197. So I've conferred, and I believe that they are willing to TIC that case if they could add conditions to his probation for any possible restitution that would have arisen out of that case.
okay. So let me pull up the other case. And that's 2025 CR 0027.
002719. That's the one that he pled on, that you gave him probation. No, excuse me.
That's this case.
Yeah, 7197. That's the one that was indicted. He's before the court. The one he got
Yes.
probation on was 2719.
All right. So what are you all requesting?
If the state had known about this case, everything would have been resolved.
Mhm.
So in order to move forward with the TIC, have probationer go on probation, which is what the court parties were wanting, we would want to amend and alter conditions to reflect what would have been done at that hearing had we known about this case. And so if we're able to add conditions to the case for which probationer was granted probation that reflect items for this theft case we want a TIC, then we would be able to resolve everything today.
Okay, Yaya, can you have them bring out this file for me? 2025 CR 002719. All right, so do you understand what's happening?
Yes, ma'am.
And are you in agreement to that?
Yes.
All right, we'll go on the record. The court is, and Ms. Abrams, this is a motion to revoke. Well, not a motion to revoke, it's an amendment of his probation. It is Wilfredo Matai, Mattei. All right, the court is calling 2025 CR 002719 State versus Wilfredo Matai. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Brian Kimbrough for Mr. Matai.
And are you Mr. Matai?
Yes, ma'am.
All right, and I'm so sorry, I forget. Is it Matai or Matai?
Okay.
Matai. All right. Mr. Matai, you're currently on probation out of this court. And both parties off the record have informed the court that this new case appeared. It's 2025 CR 007197. And both parties have agreed that the state would take this case into consideration and add conditions to your probation and cause number 2025 CR 002719 to include any restitution amount that's owed to the complainant in 2025 CR 007197. And the complainant in that case would be U-Haul. Did you understand?
Yes, Your Honor.
And is that the agreement from the state and the defense?
In addition to restitution, the state would be asking for no contact.
All right. And also no contact with U-Haul.
Is that every U-Haul
Yes,
in America or in Texas?
that's every U-Haul. So you're going to have to do it the way we did before there was a U-Haul. You call your friends, you see who has a truck, right? And that's what we would do in the past.
No U-Hauls.
Okay.
All right. So is that the defense and state's agreement?
Yes, Your Honor.
That is, Your Honor.
All right, Mr. Matai, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Wilfredo Matai.
All right, Mr. Matai, did you understand the agreement that's been reached between yourself and the state?
Your Honor.
And are you in agreement to that?
Yes.
And you understand in cause number 2025 CR 007197, you have a right to a jury trial if you so wish?
Yes, Your Honor.
And do you wish to have a jury trial in that case or no?
No.
All right. So then the court will accept the dismissal from the state without objection.
No objection.
And as previously stated, your conditions and cause number 2025 CR 002719 will be altered and amended to include restitution, if any, to U-Haul, and cause number 2025 CR 007197, and there's to be no contact with U-Haul. Is there anything else from either side?
Nothing further, Your Honor.
Not from the state, but if the state may tender.
Thank you. And probation will go over your conditions with you. And we're off the record. Counsel, do you need a setting for a restitution hearing with regards to that? All right, thank you.
Thank you.
Thank you.
It's calling 2021 CR 11807 State versus Raul Jacob Fernandez III. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Peter Calderola standing in for Gail Calderola for Mr. Fernandez, Your Honor.
Are you Mr. Fernandez?
Yes, ma'am.
Do you have any objections to this attorney standing in?
Just made a mistake and
No.
no.
Any objections?
I mean, if you have.
No, ma'am, no, ma'am, no, ma'am.
All right. Did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Raul Jacob Fernandez III, guys, we're on the record, who was placed on community supervision in 2021 CR 11807 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on February 15th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Raul Jacob Fernandez III did then and there fail to report to the supervision officer as directed for the months of March through December 2022 in violation of condition number 4.
All right, to that, how do you plead? True or not true?
The state will waive and abandon the remaining violations, Your Honor.
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison
Yes, ma'am.
and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
No.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, we don't have an agreement, but we have proposals.
All right, state, what are you requesting?
We are requesting that you grant the state's motion, revoke probationer, sentence probationer. The state recognizes you have 4 years. State is asking for 3. The state will tender TICs for 2 new number 1s at the resolution of this matter.
And Judge, that we're following that proposal.
Oh, you all in agreement to the 3 years?
Yes.
Yes, Judge.
All right, sir, are you waiving your right to appeal?
Yes, ma'am.
And are you asking the court to follow this agreement?
Yes, ma'am.
And what cases are being taken in consideration?
Possession of a controlled substance.
The cost numbers.
Oh,
if you
sorry,
have
Your
them. That's okay.
Yes, we have 2025 PF 23502.
Mhm.
And the second one, 2025 PF 23503.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed. Oh, I'm so sorry. Just one moment. The court is going to grant the motion, find violation of condition number 4 true, revoke, sentence you to 3 years in the prison, give you credit for any time served, take in consideration 2025 PF 23502, 2025 PF 23503, and the court will request the therapeutic community. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So why were you not successful?
I just messed up, ma'am. Sorry.
No, I understand that sometimes things happen, right?
No.
So here's the thing. It appears to the court that you may have a drug issue. You need to make sure that you take care of that. You'll request the therapeutic community. I have no jurisdiction to have them force you into the program or order them for you to be in the program. But if you don't ask for it, they definitely will not put you on the program. Once you're released from prison, if you can't find a sober support home or somewhere to stay or help with your addiction, you can come back to court. If I'm still here, I get you the help. You understand?
Yes, ma'am. Thank you.
Because the last time you use may be the last time you use, and only two things are going to end up happening in your situation. Either you're going to end up in and out of prison or in and out of jail, or either it may be the last time you use. You understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge. Are you
Thank you.
excused?
Yes.
All right, let's talk about that. Judge Boyd ran a pretty efficient courtroom in this one, with that signature combination of patience and structure she's known for. This hearing had two parts, both circling around adjustments to probation, terms, and one revocation, and it moved fast without losing clarity. In the first segment, we saw Wilfredo Matai agree to amend the conditions of his probation to account for a newly surfaced case involving a company U-Haul. Rather than pile on another sentence, the parties worked out a plan to wrap everything into his existing probation through what's called taking into consideration, or TIC. And Judge Boyd kept things light while making sure everyone understood the stakes. She even added a dash of courtroom humor with a nod to the old-fashioned way of borrowing a pickup truck calling your friends instead of U-Haul. Since he's now barred from contacting them, Mr. Matai was polite, cooperative, and clearly on board with the deal, showing a level of responsibility that helped the whole process wrap up smoothly. Then we moved on to Mr. Raul Jacob Fernandez III, who had a probation revocation hearing stemming from missed check-ins throughout most of 2022. He pled true to the violation, and though he didn't have a formal agreement with the state initially, both sides quickly aligned on a 3-year sentence. Judge Boyd took the time to confirm that Mr. Fernandez understood the consequences losing appeal rights, the conditions of a felony conviction, and the therapeutic support available to him. It's clear she cares about rehabilitation, and while she didn't sugarcoat the options, either recovery or a cycle of incarceration, she delivered it in a way that was firm but supportive. Mr. Fernandez, for his part, was respectful, soft-spoken, and accepted the outcome without argument. No courtroom drama here, just a judge focused on giving people the chance to turn things around, attorneys who were aligned and prepared, and defendants who own their situations. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,